All right. Welcome to the Automotive Impact Statement discussion on privacy, data rights, and data ownership. Looking forward to a literal fireside chat. I brought my fireside and our esteemed panelist, Gabriela Zanfir Fortuna, who is going to talk a little bit and really kind of answer some of my questions and some of the things I'm burning to learn about with respect to data ownership, and what's going on globally with all of the goods. But first, let me kick it over and Gabriela, give your, if you could give us a quick introduction, because you have an unbelievable background and you are uniquely positioned to truly inform us.
Hello, everyone. I hope you can hear me well. You can hear me? Okay. Good morning and good afternoon. I know that we might have participants from other time zones as well. My name is Gabriela Zanfir Fortuna. I am Senior Counsel for Global Privacy and EU Data Protection Law for the Future of Privacy Forum, which is a think tank based in Washington, D.C. That promotes responsible data practices. Prior to moving to the US about 4 years ago, I used to work in Brussels for the European Data Protection Supervisor, where I was a legal and policy officer, and I was involved in following the file that ended up to be the General Data Protection Regulation. And prior to that, I used to do research. I was a PhD student, and I obtained my PhD in law with a thesis on the rights of the data subject. So I have a bit of a mixed background in research, and then I worked for a regulator, and I was involved in policy and also in enforcement of EU data protection rules. And now I am following everything that's happening in the policy-making world in relation to data privacy, data protection, and privacy law generally.
Well, you definitely made the right decision career-wise. I mean, it couldn't be any more exciting than it is today. I wanted to start with a question that kind of frames things. I think from the US perspective, we've been thinking about privacy on and off since, say, the late 1800s, early 1900s, but we haven't done a lot with it. And I think the fundamental difference in opinion on what an American typically thinks, or a North American at least typically thinks about privacy, and anyone, particularly in the EU, is, well, the word fundamental. How do the two areas of the world see things differently?
That is an excellent question, Jen. Thank you for starting our conversation with that particular point, because indeed, it is so interesting that the United States was literally where we've had the right to privacy theorized first, right? We had a very famous article by Warren and Brandeis that literally theorized the right to privacy, and that was, as you were saying, in the 1900s, early 1900s, and then, when society evolved and the computers started to be built and databases started to be very powerful, so think late 60s, early 70s, there were a lot of debates both in the US and in Europe about how to best capture data in databases, but at the same time, make sure that individuals are not going to be impacted in a harmful way by how the data is collected about them. And for example, this was the case in Europe when benefits were started to be distributed by government, and then you needed databases to capture information about citizens. And well, even though the debates started more or less at the same time, and they were very much influenced one by the other here in the 70s, it ended up that actually, the US didn't really take the conversation home, didn't really managed to put in place a comprehensive framework to protect personal information about individuals and how that personal information is used by automated systems. Whereas in Europe, that wasn't the case. Laws started to appear in the early 70s in countries in Western Europe that were protecting something called personal data, defined quite broadly as any information related to an identified or identifiable individual. And because there was such a huge interest by parliaments, by governments, by population to have this thing regulated, it ultimately ended up to be provided at constitutional level as a right to data protection. And it ended up being protected by the EU Charter of Fundamental Rights, which was adopted in 2000. And right now, we are at a point where the right to personal data protection actually is considered a fundamental right in Europe, and it is protected as such.
And that is significantly different, and it really has led to a lot of kind of I guess very different approaches domestically here, US versus EU versus other, in other countries. And I think that as time progresses and changes are made as we learn collectively as a global, global societies learn how to process the data, things tend to change. Now, I think for the automobile, it's an interesting question to start talking about what it is that the car can collect. If we're dealing with connected or autonomous systems, and the data just, it's exponential, it skyrockets. What, from your perspective, are you most concerned with respect to data? I know that there are some new guidelines that recently came out with the EDVP, but let's just start simply with what types of data should we be most concerned about that are collected in the vehicle from your frame of reference?
Absolutely. We are at the point where vehicles collect so much data, that a lot of it is for safety, if not most of it has, the purpose of keeping people safe, right, in the car, outside of the car as well. A lot of it is very, very technical in nature. But now we are also starting to see, video images being collected. There's a lot of data that goes through the infotainment system as well. There's a lot of location data. So there is data in some of the new systems that actually monitor how whether the driver is awake or whether there is something wrong with the state of motion of the driver. So, it's such a broad range of data, from data that's completely not sensitive, the one that's mostly of a technical nature and so on, to data that can be quite sensitive. And it's a bit counterintuitive to think about it this way, but location data is actually one of the most sensitive type of data, because it shows the unique location of an individual at a given point in time. And it actually also can show sensitive information, such as one's religious belief. If a location data is very often around a certain church or a certain place of worship. Also, it can show one's state of health. So again, by showing exactly where on the map an individual goes. So location data is one of the sensitive ones. I would say equally, data that actually shows the state of mind, the state of being of the driver can also be quite sensitive. So given that we have this very broad range of data, it's actually quite difficult to, at this point, to calibrate how the data protection rules in Europe apply to these different categories of data. And I think it's absolutely wonderful that we are starting this conversation from the point of view of what is personal data. And, you know, because in Europe and under the GDPR framework, which now it's starting to being inspiring, actually started to inspire data protection laws around the world. Personal data is defined very broadly, and the rules, as well as the definition of personal data, try to be technologically neutral. So frankly, we have the same set of rules that applies to connected vehicles, but the same set of rules apply to information about students in schools. The same set of rules apply to patients in hospitals. The same set applies to all the data that goes into AI systems for different types of applications. So, you know, it's when these data protection laws were drafted, connected cars were a matter of science fiction, you know. So it's now I would say that the efforts of the regulators to detail and provide guidelines about how this particular set of rules applies to connected cars actually indeed starts from thinking exactly what from the data that goes into the car is personal data, and what is creating higher risks for the rights of individuals from that data.
Right. So looking at that, I mean, when you shift and look at the U.S. law, is, you know, just as a contrast point, obviously we have several laws that deal with the collection of information that relate to things that are, I guess, call them automotive adjacent. Most of them deal with kind of the collection of information in driver's licenses, which again really has very little to do with what your tire pressure sensor is collecting, or any of the geolocation data, or anything along those lines. We have laws that are a little more, I don't know, esoteric. There's one that deals with what videos you watch. So if you're streaming something in vehicle, perhaps there may be some protection to make sure that you can't sell or disclose the information of what type of programming is being watched in the automobile. But outside of that, we just don't have that level of granularity or sensitivity yet to protecting or even contemplating ownership. So if we have these different types of data, if we have geolocation data, biometric data, for people who are keying into their vehicle with a thumbprint, for example, or even just some of the basic safety message information going back and forth, the speed, torque. Is there anything in the EU that would create a right of ownership to that particular data, or is there anything that's excluded from ownership?
Thank you, Jen, for that question. So in the EU, there's actually not a right of ownership. We do not have that type of approach under that regulatory framework. And, you know, so let me take a step back. And we already discussed a bit about what personal data and what data is covered under these regulatory regimes, right? And then we know that, okay, these are the types of data that are covered by the rules, but then what are those rules? I think that's also quite important to mention and to take into account. So we have transparency rules that are very important about that, which means that whomever is the data subject, so the individual about whom we have data collected and used, needs to know what data about them is collected and used, and in in what manner and for what purposes. So there are transparency rules. There are also control rules, and this has a bit to do with the idea of ownership. The control rules in this type of legislative framework have to do with individuals being able to control their data by asking for a copy of their data, so having a right to access their own data, by potentially asking for erasure of their data. There is a right to erasure under this type of legal frameworks. They can also ask for portability of the data. So having their personal data once accessed in a copy, they can also ask for that copy to be in an interoperable format to the extent it's technically feasible, and then have that transmitted to a new service or a new organization. So there are some control rules that the individual exercises over their data, but that does not mean that the individual actually owns the data. So this type of regime is all about enabling the individual to have control about the data being processed about them, but not own the data, you know. So that's how that entire framework is built.
So that's interesting, because it really feels that you know, everyone's paranoid, or paranoid is probably a strong word, but everybody's very concerned about the application of some of these laws, but it doesn't necessarily automatically convey that ownership right. It's just the right to do things. It's constraints on the proper use. Now, there have been some more constraints on proper use that I think really drive the need for our industry to continue to be collaborative as we go forward, and things that really make Geneva and the Alliance incredibly important. Those are some of the guidelines and what's going on with the e-privacy directive. Now, the guidelines really kind of establish some notions, and really they're highlighting some of those privacy right concerns you're addressing. I mean, particularly they're talking about processing when it comes to biometric data. The geolocation data that you mentioned was so important, and anything that could point to a criminal offense. And obviously one of their prime recommendations is leave it locally